want, but we're just running the session straight so we can close once and we can get ready for the gala. Thank you, Lisa.
Yeah, thank you so much, Trooks the General. Distinguished ladies and gentlemen, I'm glad to announce that this next session is going to be the last panel session before we proceed for our networking events and the gala nights. And to coordinate the session is no other than Mr. Madhu Gazama, and this session is on Mediation Skills Masterclass. So if your hands are not too busy, help me welcome to the microphone, Mr. Madhu Gazama. Thank you.
Thank you very much. Good morning, distinguished arbitrators, ladies and gentlemen. As you rightly pointed out, my name is Madhu Jokari Gadzama. It is my pleasure to have coordinated and still coordinating session 6, the masterclass session. Before I call on my panelists, permit me to recognize our sponsors, Matrix Solicitors. If you're not too busy, please give them a round of applause. They're very big sponsors of this conference. Yes. I'd like to very quickly drop a quote by Louis Holtz. He's a former American football coach. Now, he has been quoted to have remarked that ability is what you're capable of doing. Motivation determines what you do. Attitude determines how well you go about doing what you're capable of doing. Now, the panel I'm about to introduce have the ability, they're highly motivated, and honestly, have been motivated by their level of commitment towards preparing for this session. So without further ado, I'd like to introduce Franca Siambella. She's a principal senior mediator at Raffles Mediation Chambers Limited. A round of applause for her. And she identifies as a Nigerian. We also have Dr. Agada Elechi, a senior advocate of Nigeria and a senior partner at Greenfield Chambers. Please, a louder round of applause for our panelists. Finally, we have the moderator for this session, no other than Chioma S. Jack. She's the Deputy Director and Registrar at the Rivers State Mediation Multi-Door Courthouse. A round of applause for her. It's too much. It's too much. Thank you very much. I'll hand over to Chioma now.
Thank you, Madhu. You're going to pay a fine for that, though. Good morning, everyone. Good morning to our virtual attendees. I welcome you to this Mediation Skills Masterclass by our esteemed speakers, Mrs. Franca Chambella and Dr. Agada Elachi, SAN. You would find it interesting to know that Franca is Nigerian. By virtue of her being a Niger wife of over 30 years, let's give her a round of applause, please. Thank you. You can view their robust and intimidating profiles in the conference e-brochure. Now, before we commence, we'd like to once again extend our heartfelt gratitude to the esteemed sponsors of this masterclass, the one, the only, Matrix Solicitors. A round of applause for them, please. Now, at a time when commercial disputes are becoming increasingly complex and taking on a cross-border and international feature, it has become imperative for dispute resolution practitioners to employ more efficient, timely, and cost-effective processes towards resolving such disputes. This is where mediation comes in. If utilized effectively, mediation can be the game changer in our dispute resolution practice, including our arbitration practice. Our speakers will take us through a mediation skills masterclass to enable us upgrade our mediation skills. And I urge us to get prepared to learn, relearn, and unlearn. You may also begin to drop your burning and practical questions on the Slido platform, and they shall be addressed during the Q&A session. Now, before I yield the floor to our masters in the game, I invite us to quickly take our first poll in this masterclass. Please, could you display the first poll on the screen, please? Technical, multimedia. Okay. Please let's participate so we can have. Okay, we have the results fluctuating. Still fluctuating. Okay, thank you so much for participating in the poll. I now invite Franca Chambella to begin the masterclass. Thank you very much.
Thank you very much. Good morning, ladies and gentlemen. I'm absolutely thrilled to be here. And I'd like to thank Choma and Madhu and all the organizers for making this possible. Yes, I am a Niger wife of 32 years. I'm Canadian born, and I have to say, I haven't met one Nigerian who doesn't have a relative, cousin, or friend living in Canada. So I feel we're friends from both sides. Okay, I'll start off with the short disclaimer we have that everything that we're telling you today is really of a general nature and should not be interpreted as legal advice. So please, the slide with the disclaimer, please. Okay, there we go. Just your general disclaimer. And I'd like to start off also by giving you our outline today. Okay, we're going to start off with a bit of a recap of what mediation is. I know most of you know what mediation is, but some are unsure, and it's good to have a short recap. So that's what we're going to do. Then we'll jump into the issue of cultural dynamics and how that plays into mediation, and we'll have a poll. And then we'll talk about some ethical considerations in mediation, in particular, how they affect the integrity of the mediation, and we'll do a poll. And then I'll hand it over to my colleague, Agada, who will talk about enforcement of settlement agreements. And also there will be a polls, and then mediation advocacy and polls. And then we'll end off with a Q&A period. So here we go. Next. Okay. Before we start, I think this slide here is very useful in that it shows the spectrum of the ADR mechanisms going from the most amicable cooperative method on the left-hand side to, of course, the most adversarial. And even before, to the left of mediation, of course, I would add negotiations between the parties as being even more cooperative than mediation. And then in mediation, it's actually the parties themselves who come up with a resolution with the help of a neutral mediator. In conciliation, of course, you've got a conciliator who takes a more active role in having the parties come up with a solution by coaching them, by suggesting solutions, much more active role than what a mediator plays. And then, of course, arbitration that needs no explanation. And then finally, litigation as the most adversarial method. So it's just a useful spectrum to keep in mind. So let's just do a quick recap of mediation. So it's a process. We're a third-party neutral mediator. So it's a neutral person, acts as a facilitator, just as a facilitator with no decision-making powers to assist parties to resolve a dispute. Mediations are voluntary and non-binding and on a without prejudice process, right? So the process is without prejudice. Of course, the settlement agreement has the validity of a contract. Parties attend in person or virtually before a trained mediator who manages the process and assists the parties in coming up to a resolution. What are some of the benefits of mediation? Of course, it's a flexible process. And the mediation is really for the parties, and you can tailor the process to the needs of the parties. As I said, it's a voluntary process, which is sometimes a bit controversial, especially when there's court-mandated mediation. So you question whether it's really voluntary. As I said before, it's confidential. It's on a without prejudice basis. There are some ground rules to mediation, but essentially the parties are free to speak out on just about anything they want to. And often what I find is that the parties come with a set of issues that they have, but when we start the mediation, you'll find out it's a whole different set of issues. And what they thought they were quarreling about was really not really the issues. Mediations, of course, can be done in person or virtually through the technology we have. And I do quite a few mediations virtually because I do cross-border mediations where I can be sitting in Canada and I have parties in Hong Kong. And that happened recently where as a mediator, I was up till 5 a.m. in the morning because of the time differences between Asia and Canada. But it's something that we can adapt to, and it's something that makes mediation all that more accessible. There's obviously less stress to the parties in doing mediations. It's not a courtroom setting. And in fact, I encourage the parties to come dressed comfortably. There's less hostility between the parties. And of course, as I said, it's more of an informal environment. Now to talk about the process of mediation, I'm going to hand this over to Agada, and I'll be back in a short while.
All right. Good morning, everybody. Thank you, Franca. Niger wife, 32 years, not a joke. And of course, there is my in-law. Where are you? Because I'm wearing this cap because of you. Is she here? Okay. There's an Idoma wife in the house, but she knows herself, so I won't mention. Okay. So the process of mediation is driven by the fact that it is voluntary. Mediation is essentially a consensual process. Now, the process of mediation is voluntary, only the outcome is binding. So for those of us who are not familiar with mediation, it is important to stress that fact. Now, when we say it is voluntary and the only outcome is binding, you need to understand it better, we need to juxtapose that with, for instance, litigation or arbitration. When parties agree to go to arbitration, all of us here are arbitrators, and there are a few who will join us. Parties either have agreed by an arbitration agreement or by a submission agreement. Once that is signed, none of the parties can walk away. As you see from the Act, it says that you cannot unilaterally walk away. But the beauty of mediation is that parties can walk away at any time. Of course, we don't tell them that they can walk away at any time. If you do that, the first thing they will do is to go out the door. So the mediation process is flexible, and that is what essentially drives it. Litigation, of course, you know, if I decide to sue Madam Chair, whether she wants to or not, she will be forced to respond in court. Now, the interesting thing about litigation as well as arbitration is that even if at some point, I decide to withdraw the suit against Madam Chair, if issues have been joined, I will need the consent of the court or the permission of the court to do that. This is not the case in mediation. So mediation ends with the parties ending up in a contract, and it is that contract that is binding. Of course, it is important that lawyers play a very essential role in mediation. And we'll be talking about mediation advocacy later. So what happens in a typical mediation process? Parties will agree to appoint the mediator. But it's important to also state that in terms of mediation, unlike every other process, arbitration, conciliation, litigation, the mediator can, as we say in law, suo motu, offer their services to mediate a dispute for parties. So for instance, I identify that there's a dispute between two companies. I'm allowed to write a letter to them offering my service to mediate. If they give their consent, then we begin mediation. Now, typically every mediation usually starts with a pre-mediation stage. And then at the pre-mediation stage, you have what we call pre-mediation conferences to agree on certain things like who will be attending the mediation, what authority that person exercises, especially if one of the parties is a company. It is essential to make sure that you have it on record who is going to. So if, for instance, I have a party, say FCDA, and an individual have a dispute and I have been appointed mediator, I must receive a letter from the relevant authority at FCDA designating the person who is going to sit in that mediation as having authority to bind FCDA. This is very important. So all of this you do at the pre-mediation stage. Now, there are two schools of thought. Some mediators have the view that, look, I don't need to see the brief or the summary of issues before the mediation. I think it's unwise, and I think Franca agrees with me. It is wiser to have a fair idea of what the issues are so that you can know how to assist the parties. And then, of course, parties go into what we call the mediation session. So next slide, please. The appointment, I talked about that. Good. Now, the pre-mediation stage is not mandatory, but it is wise to have that happen. Then, of course, the mediator will meet with each of the parties at the pre-mediation stage, or in these modern times, you can have a telephone conversation or a Zoom meeting. But you must be careful what you do at the pre-mediation stage so that you do not move the parties into the substance of the issue. There are times when, because of the nature of the dispute between the parties, the pre-mediation meeting also offers you an opportunity to do a bit of what we call caucusing. I think we'll talk about that some more later. Now, what kind of disputes do you want to do a bit of caucusing before you bring the parties together? Let's assume that there is a dispute where there's a power imbalance. For instance, a master and a servant. It is wiser to have a brief meeting with them separately before you bring them together. And then talking about the mediation stage, how does that work? Mediation can be completed usually within a day if the issues are not complex or hydra-headed. However, yours faithfully has mediated a matter that took a year to mediate. It took us 6 months to get the parties from the point where they wanted to stab each other to the point where they agreed to sit at the table. So in that particular mediation, we did more of shuttle mediation before we brought them together. So it's important to keep that at the back of your mind. Now, the process of mediation essentially is collaborative. You want to work with the parties in such a way that you bring them to excellent. Now, the mediator leads, the parties follow. What that means is that the mediator is in charge of the process, but the parties are in charge of the outcome. Please keep that at the back of your mind. That brings me to make a very important point before I go to sit down, is that the success of mediation doesn't lie on the mediator. Very important to keep that at the back of your mind. Now, I've heard about some centers who only pay mediators fees based on outcome. I have argued that that is wrong. The mediator facilitates the process. Your job is to facilitate conversation. It is the parties who reach the settlement. Of course, you need a skill set to be able to help the parties. So if you do that properly, you should have no problem. But if the parties don't reach a settlement, it's not your fault. It's the party's fault. So please keep that at the back of your mind. Then the mediation stage essentially begins with what we call an opening statement. The mediator typically will open, and then the parties will make their opening statement. So opening statement from the parties will be their story, essentially. But when the parties tell their story, the mediator does not begin in that meeting, typically, to begin to interrogate the stories. You do what we call hold private meetings, otherwise called caucusing, so that you can dig and discover what the concerns and interests are. Because at the end of the day, mediation will only work where the parties have been able to address the interests and concerns that brought them to the process in the first place. Once you're able to narrow those issues, an agreement will be drawn up. And then once the parties sign the agreement, it becomes an enforceable contract, which is binding on the parties. Later, we will talk about how you enforce that agreement. Because one of the major challenges or the problems people have with mediation is the fact that some people feel mediation is not enforceable. If that was the case before, it's no longer the case. And I'll be happy in a few minutes to give you an insight into how that works. So essentially, this gives you a brief background as to how the process of mediation works. But as we said in the disclaimer, this does not qualify you to become a mediator. Mrs. Roberts, I hope I'm on the right track. For you to become a mediator, you will need to undertake a 40-hour, minimum 40-hour accreditation and certification training. And there are a host of institutes, including our own, which offer that service. Thank you very much. Franca, back to you.
Okay. Uh-oh. Okay, we're going to start the part now on cultural dynamics in mediation. Yeah, there we go. Okay, what do we mean by cultural dynamics in mediation and why is it important? So by cultural dynamics, we're talking about values, principles, symbolisms, beliefs, stereotypes, social structures and norms that influence behavior in culture. And this is important because in mediation, we're dealing with people. We're dealing with a lot of emotions that hopefully that we can structure, that we can funnel into a settlement between parties. In the context of mediation, whether these dynamics play a role such that they impact the mediation, both in substance and in form, and whether or not taking these into account can result in a failure of the mediation is something that's very topical. You ask yourself again, why is it important, especially here where we are in Africa? Well, for example, with the African Free Trade, Continental Free Trade Agreement, it's anticipated that there's going to be more commerce between countries and more disputes and hopefully more mediations. So the cross-cultural aspect of it will become more and more important. And in fact, even now I'm hearing, South African mediators saying, oh, we can't work with the Nigerians because we can't trust them. Or, the Nigerians saying, well, down south, they're all lazy and this and that. So these cultural dynamics come into play. And I'm going to tell you a little bit about the schools of thought and what I think, given my years of experience as a mediator. And the other question is, does a different set of beliefs and values make a difference in mediation? And do we need to prepare in advance as mediators? And if there is an impact, how can both the mediators and the parties prepare for this? So there are really three schools of thought here, and there's a lot of literature on this. If you go on the internet, you'll find these main schools of thought there. And the first thought is that mediators of one culture cannot mediate in another culture, and parties from different cultures will find it difficult to mediate. And there's a lot of literature on this. And in fact, I can draw from my own personal experience that when I arrived in Singapore and I ended up staying for 30 years in Asia, I was told that I couldn't mediate because I was a white person from North America and I didn't know anything about Asian values. And that was discouraging for me to hear, but fortunately, I proved them wrong. There's another school of thought that says, no, cultural dynamics don't matter. You don't need to consider the culture of the parties. And in fact, a lot of mediators don't even look at the briefs, don't even know who the parties are until mediation day. So there is that school of thought that you don't need to know. It's just a technique. The parties show up, you do your mediation, and they leave. And then there's a third thought that says cultural dynamics do matter to a certain extent, and mainly for things to do with the mediation process, to help the mediator control the mediation room, which is the job of the mediator. and the mediator to manage the process as it happens by taking into account things like verbal language, what's happening, how are the parties doing, or is one party in distress, to manage expectations on following the rules. Depending on cultures, depending on age, gender, etc. Sometimes timekeeping becomes an issue, and sometimes adherence to rules is an issue. And then, of course, managing communications, you want to give parties an equal chance to communicate. And I'm of the latter view that cultural dynamics do matter to a certain extent. And as a mediator, it helps to prepare, to know a little bit about the culture of those of the parties coming, but to manage it. And I want to give you just an illustration of something that happened to me. I was doing a mediation in Asia, doesn't matter which country, and it concerned the separation of assets post-divorce. So it wasn't about a divorce, it was about a division of assets. And in the mediation room, you had the ex-wife and the ex-husband, but the ex-husband's mother had to come in because one asset also belonged to her, and she was going to be involved with that one particular asset in the whole mediation. So I don't know how many of you have watched that movie, Crazy Rich Asians? Anybody, hands up? Okay, so you know about the mother-in-law. You know, especially about the husband's mother. So this is what happens. She walks in with her son. Immediately when she comes in, she turns to the ex-wife's lawyer and says, "It's because of her that we're here." And the lawyer responds, "Well, Madame, your husband committed adultery." And she says, "Oh, I don't know anything about that." And right away, I saw the ex-wife cringe. She just started to, shrink in her seat. So I saw the dynamics immediately. So what we did was we dealt with the asset that concerned the mother-in-law. And that asset was dealt with, that part was finished. So I turned to her and I said, "Madame, you're finished here, so can you kindly leave the room? You can wait for your son outside, have a cup of coffee or go home, but your part is done." And she said, "No, I want to stay." And I said, "Madam, you're no longer a part of the mediation, and there are no provisions made ahead of time that you stay. In fact, no third party is allowed to stay because there's no agreement to that." And then I checked with the respective lawyers, is there any agreement that a third party stays? And they all said no. And I said, "Madame, it's time for you to leave." And she just left with a huff and a puff. Within minutes, I received a call from the secretariat, and it was, "Franca, you threw out the mother-in-law." And I said, "Well, I didn't throw her out. She's not a party to the mediation, and there's no agreement that she should stay. So I'm following the mediation rules." And I politely asked her to leave. And for weeks afterwards, whispers everywhere, "Franca threw out the mother-in-law." And I thought my career as a mediator in Asia was done, but, I dared to do that. And many mediators came and said they wouldn't have had the courage to do that. And I said, "Look, you're just following the mediation rules. I didn't do anything differently. The King of England could have been there and I would have said the same thing. I'm just following the rules." And in fact, what happened was the reverse happened. I began to get all these calls from mainland China, mediations in Mandarin, and I don't even speak Mandarin. And, it actually had the opposite effect. So the point I'm trying to make is that, cultural dynamics do play a role, but mediation is a technique, it's a process. And if you do follow the rules, and you take into account some of the dynamic factors from culture, that anybody can mediate, whether you're a Nigerian mediator mediating in Tanzania or elsewhere in the world, you can do it. So how do you manage the mediation room as a mediator? So as we said earlier, and as Agata said earlier, the mediation and coming to a resolution is up to the parties, but the process is managed by the mediator. As the mediator, that's your mediation room, and it's your job to make sure things go smoothly. The mediation process itself is also flexible enough to adapt to the need of the parties. So the question again becomes, well, if the mediator can manage any situation and follow the mediation process, do cultural dynamics really matter? And I said, my point of view is yes, to a certain extent. So how can a mediator manage the cultural dynamics? So one of the first things you do is you be aware of any imbalance of power that is there due to the party's age, gender, ethnicity. There are some cultures where age is very, very well respected. And you can see that in those cultures that some parties, especially if they're younger, may have a hesitation to speak. So you know that, and what you do is you help the party that feels a little bit, inferior, for lack of a better word, to speak up. So you're aware of things like that, any imbalance in what we call the power. You look at whether in that culture there's an adherence to rules and whether people value authority. And there are different, and whether they're going to value the authority you bring as a mediator. And so you have to set the tone knowing what kind of respect there is to authority. Timekeeping and time management. In some cultures, this is a disaster. And of course, in mediation, especially if you're trying to finish the mediation in a day, this can be very difficult. And I remember mediating in some of the Mediterranean countries where they take 3-hour lunches. And I remember saying, you have to be back. And first day it didn't work. They all came whenever they wanted. And so I said, okay, tomorrow we're having an in-house lunch. So you have to be aware of some of the cultural aspects, especially with respect to timekeeping and time management. If you know somebody's going to be late, you tell them to show up half an hour earlier. So you have to manage it and be aware of it. If you tell somebody to be there at a certain time in a place like Canada or Singapore, they will be there. In fact, they'll be there even earlier. And so you have to be aware that you as a mediator need to keep to that time as well. Communications, being sensitive to verbal and nonverbal communications. So for example, what does shrugging shoulders mean? Well, it could mean, I don't know, or it could mean, I don't care. So, knowing things like this can help you understand what's going on with the parties. So again, you don't have to agree with my view, but there is a lot of literature, and it is, as I said, a very important factor, and will be even more important as we start seeing more and more cross-border mediations. And I think now we have a poll. Yeah, okay.
Can you hear me? Okay, thank you very much, Banka, for taking us on cultural dynamics in mediation. So we're going to take a quick poll now. Could we have the poll on the slide? Just to add to the introduction by our speakers, it's very important to know the meaning of mediation, because most times you find that parties mix up the processes. A matter is referred for mediation and a party is saying, oh, the mediator will decide. But that's not how it works. In mediation, the outcome is determined by the parties, but the mediator controls the process. So that's very important. And it's also important to state that the principles of mediation are universal, regardless of the jurisdiction. Okay, so we all agree that cultural considerations play a crucial role in mediation. Thank you very much. I now invite Franca back for ethical considerations in mediation. A round of applause for her, please.
Okay, thank you. Okay, so we're going to look at some ethical considerations in mediation, because these go to the core of the integrity of the mediation. So what do we mean by ethical considerations? So as I said, these can relate. These relate to the integrity of the mediation and whether the mediation was validly held, or whether it can be enforced at all if certain important factors weren't taken into account. It can relate to the mediator's attributes, whether the mediator has done the right things, has been even adequately chosen, the conduct of the parties and their lawyers during the mediation, how the mediation was conducted, and again, as I said, generally maintaining the integrity of the mediation. Most jurisdictions are silent on ethics in mediation, and it's not covered in legislation. There are some countries that have started to put together a code of ethics for mediators, for example, in Australia. So why are ethical considerations important? As I said, they go to the core of whether a settlement from a mediation should or can be enforced because it was properly or improperly done. And you risk non-compliance. So what should a mediator do if the mediation hasn't followed ethical standards? Should the mediator remedy the situation or cancel the mediation altogether? Should the mediator resign? And then who decides? Is it the mediator or the parties and the mediator? These are all questions that come up on a case-by-case basis. And I'd like to talk to you again about a real-life example of something that happened to me where an ethical consideration, a very important one, came to be. So I was doing a mediation involving the building of an airport, and the joint venture partners had come to a dispute. And in order for the airport to continue, they had to resolve these disputes. And the mediation was taking place over a week. So for 5 days, we'd come in every day and meet and try to resolve issue by issue. But what was happening was that the results of the day were somehow being leaked to journalists and to the public, so much so that one of the partners, their stock kept shooting up. It was a publicly listed company. So at the end of the day, somebody was leaking the outcome. It would hit the journalists, and then the stock would go up, and it was complete shambles. So when I discovered this, my first inclination was, we have to cancel the mediation. It's, our confidentiality has been compromised. We can't go forward. The parties didn't want to do that. They said, this is going to be devastating for us if we don't resolve this, because we really want to continue. So I said, well, we've got to come up with a solution to stop the breach in confidentiality. So what we thought of was that each version of the day's summary would contain something different in it. So the version that I would give to Agada would have a typo on page 5. The version that I would give to Choma would have something different on page 10. And then we circulated the versions. And yes, we caught the culprit. And the culprit was evicted from the mediation room. And we were able to maintain confidentiality and continue the mediation. So the day was saved. So in that instance, you see an example of how the mediator worked with the parties to try and resolve the ethical problem. So what are some ethical considerations to think about? Well, there's in selecting a mediator. As we said earlier, the mediator has to be a neutral third party and an impartial party. And I've seen mediations where parties have said, oh, that mediator, it turns out he acted for the other party and he wasn't impartial, so I'm not going to respect the settlement agreement. Does the mediator have to be a subject matter expert or not? And my own opinion is the mediator doesn't have to be a subject matter expert, but have some knowledge. But again, whether that goes to the ethics or not is on a case-by-case basis. Ensuring the voluntary participation of the parties. As we've said a few times already, the parties should come to mediation voluntarily. And what if they're forced to and they enter into an agreement not on a voluntary basis because they felt duress or pressure? Then again, they're going to be less likely to respect the settlement agreement. Confidentiality in the mediation. The process has to be confidential as well as the settlement. And again, I gave the example earlier of what could happen if there is a breach in confidentiality. And can the mediator give legal advice? There's various schools of thought here, and you would expect the automatic answer to be no, never, no way. There are instances where mediators can point to general information or to general sites that have information on law. For example, what is the corporate tax rate in a certain jurisdiction? Well, a mediator can tell the parties, look, you can Google this and find this out. But there are schools of thought that say a mediator can even go further than that. So just to remember that, the automatic answer is no, never. And there are other schools of thought that say yes to a certain extent, and provided that the same information is given to all of the parties. The outcome. So a big ethical consideration is whether the settlement agreement really represents what the parties wanted, the parties' will. If there's a settlement agreement that differs from what the parties actually said, then it's not going to be valid and it's not going to be enforceable. Now, should the mediator be concerned if the settlement is fair? And the answer may surprise some of you, and the answer is no, the mediator shouldn't care. As long as the settlement represents the will of the parties, it's not up to the mediator to judge whether the settlement agreement is fair or not. What the mediator needs to ensure is that the settlement agreement really represents what the parties have said that. And the mediator does so, of course, with the representatives, the lawyers of the parties who draw up the settlement agreement. Sometimes if there's a draft consent order and the settlement is filed in court, a judge can review it. And I've seen judges review some settlement agreements saying, wow, is this really the will of the parties? Because it seems to be favoring one party over the other. But again, that can happen in court, but that's not the job of the mediator. The parties' behavior in mediation, if there's bullying, threats, and what should the mediator do? If there is any bullying or threats, that needs to stop immediately, and the party doing it is usually given a warning. If it happens, if it continues to happen, then the mediation will have to stop. Then we do a timeout and we come back another time when emotions are less intense. But there also has to be a warning to the party bullying and threatening that they won't be allowed to do the mediation if this behavior continues. And what does without prejudice mean in mediation, and can we really ensure it? So, of course, without prejudice is that anything said in the mediation can't be used later on. But however, in mediation, you can't help but learn a lot about what the other party's position is. And if the mediation is not successful and you continue in court, while you can't quote from the mediation or use documents from the mediation, you still have that knowledge of what happened. So, the without prejudice, yes, it's true, but you do leave the mediation with some knowledge. But the ethical concern is actually using information obtained from the mediation for other purposes. Okay, I think we're going to do another poll at this point. Yeah.
No. Could we have the next poll? Thank you so much, Franca. Thank you so much for an insightful presentation. Could we have the next poll? Could we have the next poll on the screen, please? Okay. Okay, so we have 100% for, okay, it's fluctuating. So the question says, are there any circumstances where a lawyer for one party can act as a mediator? How about with the party's consent? So we have 50% for number one. A party's lawyer is conflicted and can never act as a mediator. But it's still fluctuating. Thank you very much. I now invite Dr. Agada Elachi, LCN, to speak to us on enforcement of mediation agreements. A round of applause for him, please.
All right. So following what Frank has just talked about, the logical reason why parties go to mediation in the first place is to reach a settlement agreement. As I stated earlier on, the settlement agreement belongs to the parties. Now, a key point that I like to emphasize, especially for those of us who are new to mediation, because we've been, Chioma has mandated that we should pretend that more people in here do not know about mediation than those who know about mediation. So we should ignore that the fact that Madam Chair is a mediator, Mrs. Roberts, and a host of others are mediators. The thing to know about mediation is that mediation will only work where parties are in an ongoing interdependent relationship. So whilst mediation is probably the most effective dispute resolution mechanism in the world, and I stand to be corrected, it only works under certain circumstances, which means that if the parties do not have something to gain from the future of their relationship together, please do not resort to mediation, so that we do not have people thinking that mediation is one size fits all. Now, what is the nature of the mediated settlement agreement? Now, settlements in mediation are achieved through voluntariness and consensual bargaining. We can't emphasize that enough. So whilst, as Franca talked about earlier on, one of the major challenges with ethical considerations in mediation is whether the mediator can give advice. One of the reasons why traditional mediation training says you cannot give advice is that you want the parties to feel that they own the outcome. However, mediation has advanced, so there are also aspects of mediation now called evaluative mediation, or which is more of what you find in court-mandated mediation. In those kind of mediation, sometimes the mediator is mandated and given some latitude to be able to do some evaluation of the issues as they exist between the parties. Now, this voluntary nature of the mediated settlement agreement helps to ensure voluntary compliance by the parties. The reason why you want the parties to be the ones to agree on the terms of their settlement is so that they can willingly comply. One of the questions that Franca brought up was, can you say that the mediation agreement, it was a dispute involving property? At the resolution of the dispute, one party was only interested in an apology. And once that apology was rendered, that party was willing to surrender all the title documents to the other party. So what is of value to a party usually is different, particularly in mediation. So it's good to keep it in mind. Now, the success rate of settlement agreements reached via mediation is in the range of 80 to 90%. And this is based on statistics from all over the world. So when parties reach their own settlement, you don't need to enforce it. But the reality is that sometimes you may need to enforce. And that is why we're having this conversation. Now, the mediated settlement agreement is otherwise referred to as the MSA. So if I say MSA, I'm talking about the mediated settlement agreement. It is the embodiment of the final resolutions by the parties of the issues in dispute between them. So a typical mediation agreement will touch on virtually everything that the parties are talking about. Now, it's important to state what makes a mediated settlement agreement unique from, for instance, an arbitration and award or a judgment. Let me give a hypothetical example, a case of a landlord-tenant matter. In a landlord-tenant matter, when the landlord goes to court, what the landlord is asking for what? Possession, recovery of their property. And then the tenant usually will throw up issues like proper notice and so on and so forth. In mediation, it may be discovered that the reason why that dispute exists in the first place is that the landlord has a 17-year-old son and the tenant has a 16-year-old daughter. And they are beginning to frolic in such a way that there is a possibility of accidental discharge happening at some point. That is not an issue you can bring to court. Is that not true? But in mediation, that can be dealt with. And that's why the mediation agreement is so unique. When parties sign the agreement, it ends the process of mediation. And compliance, as I said, is usually a given. But then parties sometimes do not comply with the terms of agreement, either because certain dynamics in the settlement did not play out as they had hoped, or sometimes parties are just recalcitrant, or sometimes parties are just mischievous. Now, if there is now need to enforce the settlement agreement, what do you do? How do you enforce settlement agreements? Now, you can enforce them in a number of ways. One, as a contract through an action in court. Another is as a judgment of the court. Another is as an arbitral award, as a consent award, as you see. Another is that it can be enforced through a multi-door courthouse. So if, for instance, the matter is at Chioma's multi-door courthouse, it can be enforced through the multi-door courthouse. And it's important to note that Section 82 of the Arbitration and Mediation Act, 2023, provides for how we can do all of this. So let's talk about enforcement as an action through court. So typically, parties have gone to mediation, particularly an ad hoc mediation, and they've reached a settlement. Remember, that settlement at best is a contract, but the contract is not self-enforcing. So what do? Parties can take that agreement. The party who is seeking the enforcement can take that agreement, approach a court, and ask for specific performance. And one of the things we've been advocating is that our courts, and I'm happy that the session yesterday, and my lord, you managed that session on guerrilla tactics. I think that our courts, if our courts are a bit more flexible in the time and the way they handle such matters, that such a matter, for instance, in England, a matter of that nature will not last in court more than 2 months, and it can be dealt with quickly. So that's usually what would happen in that case. And a party who has failed to comply, the only defenses available to such a party is if that party can demonstrate that in reaching that agreement, they reached that agreement by way of either coercion, misrepresentation, fraud, duress, and so on. So essentially, once the agreement is one reached in a mediated settlement, chances of finding a way out of it will be quite hard. The downside is that, of course, the fact that you have to go to court will extend the dispute, and then, of course, it will cost you more money. Hence, some of those who are naysayers against mediation will say to you, why did I have to go to mediation in the first place? Why didn't I just go to court? My answer is this. As at mediation, you now have an agreement which narrows the issues. And so that is a better place to be than to go to court to try to ventilate the issues altogether. Then, as a judgment in court, it is possible that sometimes a matter has already started in court, and the judge and our rules of court provide for that. There are elaborate provisions across the country, different jurisdictions. In FCT, it's our Order 19. I think in Lagos, it's Order 25. They provide that the judge can direct parties to go to mediation. So a matter which is already in court, parties have gone to mediation. They've reached a settlement in mediation. They can bring that settlement agreement back to the judge, who will endorse on it as judgment. And that judgment then becomes enforceable per se as between the parties, and you don't need to do more. Also, if the matter was one that was filed at the multi-door courthouse, and even though it was not referred to the multi-door courthouse by the judge, and it was a walk-in, at the multi-door courthouse, if a settlement is reached, because it's a court-connected ADR center, and most multi-door courthouses now have what we call an ADR judge. Through a certain procedure, that matter will be, the settlement agreement will be endorsed by the ADR judge, and then it becomes judgment of court, which means that if a party doesn't comply, you can then enforce it. So it becomes enforcing. Then sometimes it may be a matter that is already in arbitration. I know that I'm doing an arbitration now where we've taken a pause and I've encouraged the parties to go and attempt mediation, because looking at the fundamental issues in dispute between the parties, I see that there is a relationship that the parties ought to attempt to save. And the Arbitration and Mediation Act, interestingly, enjoins us. It enjoins the court and enjoins parties, the arbitrators, to actually refer such matters to mediators. The key thing to note is that it is safer, even if the parties give you their consent, it is safer to avoid being the mediator in a matter where parties are already before you as arbitrator. Please, I would encourage that you avoid that. So when the parties go to mediation, if they reach a settlement, they can then bring that settlement back to you, and you can enter as consent award. And that brings to an end that matter. And once that is done, then it becomes an award that you can enforce without more. And then, of course, it's important, we can't talk about the enforcement of settlement agreements in mediation without also talking about the enforcement of settlements in international mediation. And this brings us to the Singapore Convention. And I'm happy to, Franca mentioned to me earlier on that she was there when the convention was signed at Singapore. Now, for those of you who are not familiar with it, the Singapore Convention is to mediation just as the New York Convention is to arbitration. I think that's the simplest way to put it. But what the Singapore Convention has done is to create a legal framework for enforcing settlement agreements reached in mediation internationally out of international commercial transactions. Prior to the Singapore Convention, there was no framework anywhere that allowed for the enforcement of settlement agreements reached via mediation. So if you, for instance, mediated an international dispute, you still, if you needed to enforce it, you still had to fall back on the local courts. With this now, we now have a framework, and then of course it operates exactly the way the Singapore or the New York Convention does. Of course, it has certain restrictions and section exceptions to the application of the convention, but all that it is important to say to you this morning is that you can enforce mediated settlement agreements internationally now. I think that's time for us to then take a poll. Thank you.
It's time for our next poll. Could we have it on the screen? A round of applause for Dr. Agada Elachi. I think we have 2 polls for this section. So we have a greater percentage saying no. Okay, so could we have the next poll, please? Could we have the second poll for this segment? Do you still have it? You can wave if you don't have it. Okay. Okay, so before we continue, I just want to talk about the importance of enforcement. Personally, I prefer enforcement through the multi-door courthouse, because the beauty of the multi-door courthouse is that if it's a case referred from the courts, when parties settle, you send the settlement agreement back to the court, and the court adopts it as consent judgment. While if it's a walk-in case, we send it to the ADRO judge. It would interest you to know that Justice Lemia Umbo, who moderated the guerrilla tactics section yesterday, is one of our ADRO judges at the River State Multi-Door Courthouse. A round of applause for her. Over to you, Leonard Silk.
Okay, and just to write down that is that at one of the things we are now advocating using the conference of multi-door courthouses is to allow matters that are being mediated outside the multi-door courthouse to be taken to the settlement agreement, to be taken to the mediation multi-door courthouse, and to have, through certain procedural checks and balances, to have the ADR judge endorse on that. So that even though it's from an ad hoc mediation, not within the framework of a court-connected ADR center, it can still become enforceable using the multi-door courthouse. We have succeeded in Ogun, and I think in, where? In Rivers. Oh, beautiful, in Rivers. There's still a long journey. We haven't succeeded in the FCT yet. Sorry, ma. Oyo State, excellent. So there's great progress. Lagos is still dragging his leg, but there are more Lagosians here. So I'm sure that Madam Chair will make sure that that happens. All right. Okay, we'll move on. We'll take all your questions at the end. We want to be able to do all of this and then take all the questions at the end. My task now is to speak about mediation advocacy. I'm sure an area which will be of particular interest to those of us who are maybe not necessarily mediators, but those who are interested in acting as counsel in mediation and all that. Now, mediation advocacy is a technique of presenting and arguing a client's position, needs, and interests in a non-adversarial manner. So, I mean, just imagine how you want to put your client's interests and needs. I can see Emeka Ozani, SN. I don't know, how would you do that, sir? Because I know you are a litigator per se, but that you are in the room is a good thing. So doing that is what mediation advocacy is about. It's a special skill because as mediator, and there's a mediation I'm doing currently, and I'm hearing counsel saying things like, I object to this particular document. And I have to remind counsel that this is not arbitration. And even in arbitration, and of course, you are the evidence. Now, mediation advocacy is a new specialized skill within the existing dispute resolution market. A good mediation advocate is a solution and settlement advocate. So essentially, when you are a mediation advocate, what you are doing, what you are selling is settlements. So when parties, for instance, I no longer introduce myself as a lawyer. What I introduce myself to people as is I say I'm a settlement provider. I'm a solution expert, because I can provide that solution for you, even in litigation. That's what we do. I mean, we're providing solutions, we're providing settlements. It's just that the nature of the settlement is what is different. Now, what mediation advocacy seeks to achieve? It seeks to achieve the following: a negotiated outcome to a dispute. This is usually more satisfying, more effective, more workable, more flexible, and more durable than any other imposed by a court or other tribunal. I've just been invited into a matter that was decided at 2 lower courts, and now they're going to the Supreme Court. And after reading the file, and I think I was discussing with somebody here, somebody who was counsel at the earlier stage, I gave them an opinion. I said, well, let us file the matter at the Supreme Court. But the beauty of it now is that the Supreme Court has a settlement mediation center. Now, this is a matter properly suited for that settlement. Because even if we're able to overturn the decisions at the Supreme Court, for whatever is worth, implementing that decision will be impossible. And I'm sure many of you are aware of decisions that were taken by the Supreme Court involving communities, particularly in the oil and riverine areas. Some of those decisions have never been implemented. And that's really where mediation advocacy can come in help. So parties control its process and its outcome. The assistance to parties, the assistance of the mediator is to assist parties to reach a settlement that both deals with all the matters and issues and also meets their true needs and wider interests. The example I gave earlier on about the landlord-tenant issue is a real case. By the way, it's not, I didn't make it up. Now, in that particular matter, the parties had a beautiful relationship, had lived together for about 18 years in the same compound. One of them had built a house, twin flats. The other, his colleague in the workplace, had elected to take on the second flat. Fast forward 18 years, the other had made enough money to build a house, built his own house elsewhere, but decided that, when you are living in a place and you feel at home, say, I feel so good here, let me continue here as your tenant while that is going on. So that's how beautiful their relationship was. And then this naughty issue of their children came up. That is an issue that is not in law, but is an issue that addresses the needs of the parties, the concerns of the parties. And that's what mediation advocacy. So as a mediation advocate, your duty is to help parties find an option, a soft solution to their problem, and not necessarily to follow the legalese of the law. Now, what is your role as an advocate in mediation? Your role will be to properly prepare for the case. Now, preparation here is not about the technical aspect of preparation. Preparation here is to sit down with your party. For instance, one of the things that I do with clients when they come to me now is to ask one fundamental question. What was your relationship with this party prior to this dispute? This is very important. And in the early days of practice, it was difficult, for instance, to reject a file based on the fact that I thought this was a matter better mediated than litigated. Well, with the benefit of age at the bar and all that, it's easier to now look a client in the face and say, sorry, this is a matter that should be mediated, not litigated. But of course, sometimes a client may come from maybe my former chair, Tunde Busariese, and has sent the client to me. And I don't want to say no to him. So the trade secret I can offer those of us who are younger is that when such a client refuses to take the option of mediation, give them a bill that will send them away. That is the only way. Now, your job is helping the client to keep his or her emotion under control and assist the mediator to prevent walkaway. So the mediation advocate is a partner with the mediator. So you do not go there representing just your client's interest. You are working hand in hand with the mediator to help your party, to provide the mediator with details and facts that can satisfy your client's interest. One major challenge you find with lawyers in mediation, and those of us who are mediators know this, sometimes lawyers can become the bottleneck. Part of the problem sometimes, again, is because the lawyers try to drive away the mediator tries to chase away the lawyer. I embrace the lawyer when the lawyer comes to mediation. In fact, I make the lawyer my partner in the process and all that. So I said to the lawyer, I understand that you know all the nuances, the technicalities about this case. But sometimes what I want to hear is the feeling of the party about how they feel, what they feel the wrong is as it relates to them, not about the money. So distributive issues, money issues and all that the lawyer can help with. But the emotional issues, I'll tell you another one. There's a matter that I had the privilege of being mediator. 2 companies at loggerhead, CEOs. We tried everything and it wasn't working. We didn't have the benefit of the mother-in-law in that one, you know. Yeah, Franca's mother-in-law in that one. We tried everything, it wasn't working. And then I decided to do a meeting with the caucus meeting and ask, is there more to this issue that you are not telling me? Well, guess what? I discovered that there was a girlfriend issue from university days, a grudge that one party was still holding against the other. So this can only happen in mediation. You can never see it in litigation. So the advocate will ensure that the client arrives at a decision which remains within the legal framework. So whilst the mediation advocate is to help the parties meet their needs and concerns, your job is to make sure that they don't reach a settlement that also is outside the framework of the law. And that's why you are there to assist them. Now, I'm sure most of you will be interested in this, getting paid. If you are a mediation advocate, how do you get paid? It's important to get paid. Because if we don't address the issue of getting paid, many of you will not be interested in doing that aspect. I hear, as I was sharing with Franca earlier on, I hear from lawyers most of the time when you say, let's go to mediation, they say, oh, that's an alarming drop in revenue. But I say to lawyers, you can still be a mediator or a mediation advocate without losing money. How do you do that? You can do like Okay Akobondu. When they come in, you charge them your fees properly. So take your fees. First of all, do not tell them you are going to mediation. So embrace the matter. Whatever process you do to normally onboard a case, take that. So if it's 5 million, 10 million, 20 million, take that. Then tell the client you want a few days to review the file. Then after you have reviewed the file, you say to them, your strategy for doing this case is that you start with mediation. Have you not earned your fees? You have earned your fees. But just in case you do not have that strategy in mind, you need to first of all decide when you are charging in mediation advocacy 5 factors that you need to consider. 1, the suitability of the dispute being settled by mediation. This is very important. The amount of work you need to do to prepare, for instance, statement of issues is important to keep that in mind. The amount of hours that the mediation is likely to take. Most of the time we think that mediation can be easy. Mediation can happen in 30 minutes. But as I've said, I have done a mediation that took me a year, 1 year. And I'm doing another mediation now that we have been at for nearly 3 months. Sometimes the issues can be hydra-headed. The number of sessions that may be required, and if successful, you will still need to assist the parties to draft the terms of settlement. So all of these are important. Then, of course, an advocate may take into account factors that you consider when you are billing. An advocate should take into account all or any of the following to ascertain the value of the services they are rendering. The fee must be reasonable and commensurable with the service rendered. The time and effort required to be spent, whether you require special skill or service, and whether this will be required. If it's a simplistic matter, no problem. But if you require some special skill, then why not? The amount involved and the value of the subject matter, the experience and the ability of the advocate, and then the contingency or certainty of compensation. Sometimes parties may come to you and they may not have as much as you desire them to pay. What I have learned to do over the years is to arrange the fees, take a fee, and then agree on something called what I call a success fee. So if we get a success fee at the end of the day, why not? And then what are the options for billing for fees? The billing for fees can be per hour. So you can choose to bill per hour. Proper record, but you must keep proper records when you bill per hour because you owe the client that obligation. How much you bill per hour is different. Professor Donigay can decide to bill £4,000 per hour. Why not? If you feel that you are up to it, why not? But the key thing to keep at the back of your mind is how complex are these issues. I've just been invited to a mediation where the parties say, oh, yes, the court has directed us to mediation. It's at a particular center. I won't mention the center for confidentiality purposes. But you see, at Lagos Multi-Door Courthouse, they don't charge us like this. And I said to them, well, the rules of this particular center, which the court has directed you to, gives me a scale of fees. And the scale of fees in itself is a guide. So you can base as you feel. Then, of course, you can charge per session. That's also another way. And a typical mediation session is about 90 minutes or thereabout. And my strategy usually is I charge usually per session. I prefer per session. Is more, accountability is easier. Then I ask for a deposit to cover 10 sessions. Typically, that's what I ask for. So if at the end of the 10th, if we are by the 7th session, we are not making progress, I ask for a further deposit. If we finish by 2-3 sessions, I send you back your money. But the point is that it's so clear that sometimes it makes the parties more comfortable to embrace that. You can also charge a ballpark sum. I usually avoid that because when you charge a ballpark sum, it looks to the parties that all you are interested in is your money and all that. Because when you charge a ballpark sum, it means that the parties have to have a sum that they are quarreling about. The disadvantage is that sometimes when the parties come, the issues are not necessarily about a particular sum of money. It's about issues that you cannot necessarily quantify. That's why sessions or per hour may make more sense. Now, whatever billing for fees you do, I also do what I call billing for fees can be what I call the mediation and litigation combo fee structure. What do I mean by that? Sometimes, especially if I'm counsel in a matter, I see that this matter has potential for mediation, but a party is not willing to come forward or embrace it. What I normally would do is, let's go to litigation. We'll file all the processes. And then somewhere down the line, especially after we've received the statement of defense and all that, and we see that issues have been joined, I then bring up the issue of possible mediation. I call it LitMed, litigation mediation. The advantage is that if you have a party who already believes so much in their case and you are trying to convince them to go to mediation, they will fight back. But when you've taken the matter to litigation, and then you subsequently say, well, we have made good progress, the issues have been joined, why don't we have a conversation about this? Sometimes it douses, the parties know that you tell them, what is the worst? Let's give 13 days, 14 days, 2 weeks. At the end of the day, if we don't make progress, we'll come back to the litigation. So it gives them that assurance, but you have made sure that you've collected your fees, because when the chiefs are down, why are we doing all of this? Is to make sure that we get paid. Thank you very much. I think we have another poll.
Thank you very much, Leonard Silk. So we have another poll coming up. Could we have the next poll, please? While we wait for it, I would like to add that mediation advocacy is so important because some lawyers come to the mediation table with their litigation cap. And when they come into the process, they inadvertently frustrate the process. But mediation advocacy is about representing your client's interests in a non-adversarial way to move the process forward to amicable resolution. So it's very important that lawyers undertake mediation advocacy training. So even if you don't want to be a mediator, you should undertake mediation advocacy training. Okay, so we have the poll up. How often have you acted as a counsel in a mediation? Okay. So we have 50, okay, it's fluctuating. We have a greater percentage saying 1 to 10 times. That's quite encouraging. Okay, now we have 62%. Okay. Thank you very much for participating in the poll. Could we have the second poll as well? Did you have any training in mediation before you acted as counsel in a mediation? Okay. Okay, so we have a greater percentage saying no. Okay, thank you very much for participating in the poll. At this point, I would like to invite our speakers to give a summary of all the topics presented so far. So I would like to invite Franca to the podium. Or you can actually summarize from there. That's fine. Yes, that's fine. Is it coming on? Is there another one on the other side?
Otherwise? Can you hear me? Okay. That's better. We tried to provide in this masterclass an overview of 4 subjects that we thought were very pertinent at this point in the evolution of mediation, not just in Nigeria, but on the continent and in the world. We could have spoken on many, many other things, but we tried to hone in on these 4 subjects of cultural dynamics. And again, the importance of factoring that in, especially with, the Continental Free Trade Agreement and more cross-border disputes occurring. And even within different, groups, even within Nigeria, important to know of some of the cultural factors. Agata, you were telling me about the eye contact differing from one ethnic group to the other, even here in Nigeria. And then we tried to look at some ethical considerations and, when, that goes to the integrity of a mediation and what you can do to remedy it. And of course, the extreme is to cancel the mediation or to try and save the mediation by fixing the ethical issues. And then Agata went on to talk about the settlement of mediated agreements. And as he correctly pointed out, I was pleased to be at the signing of the Singapore Convention in, 2019, April 19, 2019. And the Nigerian representative was there, and Nigeria was one of the first countries to sign. And Nigeria also ratified, and it went into force in May of this year. So in this instance, it is my opinion that Nigeria has done everything right. And then talked about, Agata talked about how you can enforce a mediated agreement locally using the multi-door corridor facility and the courts. And then finally, we looked at the new area of practice, mediation advocacy. And it is a relatively new area, as we saw in the polls. Not many of you have done it, or if you have, it's been very little and often without training. And I think it's going to be a new discipline. And Agata talked about different ways that you can be compensated for it. And not worry about losing revenues. And losing revenues for litigators by going to mediation is something we see all over the world. I see that in Singapore, I see it in Canada, that there's a hesitation, even though we as lawyers are supposed to act in the best interest of our clients. But there is, this thinking, well, litigation is my bread and butter, and am I just going to give it away to mediation? So Agata presented various ways that you can be rightfully compensated in mediation advocacy. And one of the ways that I see more and more is being given a bonus if the mediation succeeds. In fact, I actually acted as a mediation advocate in a large cross-border matter, and we resolved it in a day. And my client gave me a very nice bonus for having done that. And so that's something that you can, negotiate also ahead of time. And I also just want to add something about how we sometimes do mediations differently. Most of the mediations I'm involved with, we do pre-mediation stages, but we try to do the mediation in one day. So it's not uncommon that the parties come in at 8 a.m. and we stay until we're finished. And the reason for that is we feel that if they go home and think about it, they'll come back the next day and they'll have changed their minds. Or if they wait 2 weeks, they forgot what was said. And again, everything, all the hard work that was done in the previous session is sort of set aside. So one way of doing it is to plan to get it all done in a day. And I often joke with the parties by saying, we're here, I'm locking the doors, we're here until we're finished. And I've had mediations that have gone on till past midnight, way into the wee hours. But again, it's on a case-by-case basis. If you see the parties are getting tired, you may want to postpone. But there is benefit to getting it done all in one shot. And as they say, an imperfect settlement agreement is better than no agreement at all. So I think that's the summary that I have. Agata, if there's anything else you want to add.
Thank you so much, Franca, for that very comprehensive summary. Thank you so much. Thank you. So now we've gotten to the Q&A session of the masterclass. It's time to bring all your burning and practical questions. I see a few hands.
I just want to say one last thing. Sorry. So Agata keeps referring to Franca's mother-in-law. That was not my mother-in-law. That was a mother-in-law in a case. I'd like to tell you, my Nigerian mother-in-law is a lovely lady, and I've not had mother-in-law issues.
Thank you for the clarification, Franca. Thank you. Thank you. Could we have the microphone, please? So we have 1, 2, 3, 4, 5, 6, 7. And we also have some questions on Slido. My dear speakers, who do we begin with? Do we begin with Slido or do we begin with the... Okay, let's take the audience first. Audience first. Microphone, please. No, they have... Could we have the microphone, please? While we're waiting for the microphone, perhaps we'll just take one question on Slido. So this is addressed to Dr. Agada Ese, and it says, Dr. Agada, if you write to disputants and offer your services, how do you charge them, or is that going to be pro bono?
Okay, so first and foremost, it depends on the nature of disputants and all that. I don't know what your calling is as far as mediation is concerned, but I always say to people that I practice law, but mediation is a calling for me. And I desire to always promote peace. So in that regard, my default is to always work to see how I can get people settled. So if it's a minor dispute involving people that I know and all that, yes, I can do that for free, depending on the circumstance. But if it's a corporation and the issues involve money, why should I work for free? So I have offered you my services. I will, if you accept, then I'll send you my terms of engagement. That again forms a base of settlement. Now, let me tell you the instructive thing about when a mediator offers services and parties agree. If you offer your services and parties agree, that's a win. It means that parties can agree on something. If you send your terms of engagement and parties agree to that, that's a second win. And my training, and I'm sure that every other mediator in the room knows that if you keep getting yes answers from parties, the likelihood of reaching a settlement is greater. Thank you.
Thank you very much, Leonard Silk. I think we have the microphone now. Go ahead, sir.
Okay, thank you. My name is Yinka Kutoye, and my question is directed to my brother, Dr. Agada. I practice in Lagos and with presence in Ogun. My experience, I would like you to speak more on the enforcement mechanism which you had adopted in Abuja. And I'll share these 3 experiences with you. It's going to be brief. The first one, I don't know whether Mrs. Yinka who is in the house, I'm not sure if she can remember that particular case, where she resided as the mediator. I think it was one of her first few cases in Lagos. And we reached a consent agreement, which we took back to court, and it was filed, adopted. I tell you today that the other party that was supposed to do or comply is at the Supreme Court on the same consent agreement. That is the first scenario. The second scenario, which is still live, mediation participated. Let me give disclosure, and Mrs. Aroye could bear me out. I was one of the first persons who challenged her. As a young counsel back then, I just could not broach going before a mediator on a matter I believe is strictly we should resolve in court. And the two of us usually had these front and back arguments those days. Now, the second scenario is live and it's still on. We've reached a consent agreement. The party had defaulted in the payment. 4 tranches. They had defaulted in payment. I'm being constrained to go back to that same court for either garnishing proceeding or to go and use a belief to levy execution. Now, my question, is it not possible to have an independent enforcement structure within the mediation system so as to forestall a situation like this? Permit me to disagree with you on the scenario in Ogun State. I have a live issue currently. I looked at it when I was briefed. It's against the state government, and I called the AG, who is my friend. Said, who could resolve this matter? He agreed. By the time we got to court, the Solicitor General came and said, oh, he didn't receive instruction to discuss that, and I left it at that. The judge by himself, Suomoto, in the course of proceeding, said, gentlemen, why can't both of you resolve this matter? And I said to the judge that I'd mentioned it to my learned friend earlier, but he said so, and I didn't push it any further. Only for immediately after that proceeding, by the time I got back to Lagos that evening, I received a letter from the Solicitor General saying I lied in open court. So I had to go back now to read the rules of Ogun State again and start digging into the LMDC, the equivalent of the LMDC rules. I noticed the lacuna that they don't have the equivalent of our Order 25, where the judge can compel parties to go for mediation. And I also noticed that their mediation rules is not as particularly detailed as what we have in Lagos. I don't know about Abuja. So I called the head of the mediation center, who is also someone I'm familiar with. And he said they are still at a teaching stage, that they don't even have any regulation. So that's why I said I would disagree with you on Ogun State. I don't know how you can come in to assist them in that area. Because for me, in spite of my initial attitude, I think I'll find mediation very pleasant. I've had some other sessions that we ended in less than within 2 or 3 cities. We were able to come to terms and we both shook hands and we left. So thank you so much.
Thank you very much, sir. So we'll take all the questions at once.
Host, please, can you let them know that there's a question online? Thank you.
Please, let's
Can the
keep our
host please let
questions
them
as
know?
brief as possible, please.
Thank you.
Thank you.
Thank you very much. My name is Omolola Ikwagu. I'm from Lagos. The first question is on the issue of the voluntariness of the mediation proceedings. In courts in Lagos, well, I'm familiar with the Lagos jurisdiction. At times, the other party comes and brings an application for recourse to mediation, and the court directs mediation in spite of the objection of a party to the dispute. Can the proceedings in that case be said to be voluntary? Because many times in my own experience, the other side who objected to the mediation proceedings remains a stumbling block throughout, objects to fees being paid where the mediator insists on fees, objects to dates and everything, and just ends up wasting further time. How do we address such a situation? And the second question I have is, well, where an arbitrator, like you said here, refers a matter to mediation. We've heard the case of the Kenyan lady who said that an arbitrator referred the matter to some tribunal. I think the surveyors or something, to make a survey and report back. So if an arbitrator refers a matter to mediation, would the litigants or would the parties before the arbitration also be entitled to request a refund in their fees?
Thank you very much. Next question,
Okay,
please.
Good morning, everyone. My name is Farouk Abbas, and my question is directed at Daniel Silk. So I concluded a mediation recently. I was a counsel to one of the parties, and we couldn't resolve on anything. And during the mediation, I felt that the mediator didn't take charge of the proceedings. And what do I mean by this? I know the mediator cannot compel parties to resolve or put parties under pressure to resolve. But when a party is blatantly stating demands that don't make any sense, they are not logical given the facts of the case, I believe that a mediator should be able to take charge, even if it's by caucusing, to advise the party and tell him that what you're saying doesn't seem to make sense. Why not consider this? So we had about 2 different sessions and we couldn't even agree on anything. And I was very disappointed. And I've also done mediation in the past where we couldn't resolve. We went back and I saw that we were able to achieve success based on the action of the mediator, the maturity. So when Lanet Silk said whether they settle or not is not the mediator's business, that you don't have a role there, I found that it didn't sit well with me, because I've done a few where I commended the mediator, and I'm always happy to appear before some of them because they have the maturity to handle the dispute. And whenever we have disputes, especially at the Lagos State Multi-Job Courthouse, because I've handled several there, they are always very fantastic. And now I'm at the level in my practice whereby I even prefer mediation now to litigation, because we resolve matters faster through mediation. So I'd like to have your thoughts, and I also have to like the other speakers' thoughts on that position, so that can a mediator guide, give comments that can advise the parties. Thank you very much.
Thank you, sir. Next question, please.
Okay, my name is Juliet from Delta State. My question is on the legal advice to parties, because I've been involved in a mediation where the parties asked me to interpret an MOU which they entered in 2003. And I realized, because they are communities and they both shared an oil well, and I knew that situation was very volatile. And I knew whatever interpretation I gave to them, if I was not careful, could cause problems, because they had disrupted the operations of the company. So when they came to me, I had to read the MOU. And I found out that because one of the communities was claiming that they had the shared oil well and all other facilities in the community, but the MOU only talked about the shared oil well. So when they brought it to me, I had to read it. And what I did as well was to look at the PIA, because it's the PIA that regulates their relationship right now. And in the PIA, I saw that a host community under Section 318 was defined as a community which was 5-kilometer radius to the operations of the oil company, a community which was also appurtenant to the oil company, and a community which the oil company decides to take as its host. So when I got that, I held their MOU. And when they came before me, I was like, I have interpreted this MOU to mean that the oil well, the benefits is just this oil well that you share together. And I saw the other community they were angry, all their representatives. And I said, well, the oil company at the same time can choose whatever community they want to as their host community. So I saw that they were so happy at the end of the mediation. They signed the resolutions that we had. So there are certain situations where I think the mediator can interpret a document, but I think that the mediator should be very careful. So I want to put it to you, was I right in doing that? Although I had a very positive outcome. And then the second question is...
Thank you, madam. We've actually run out of time.
The second question is keeping to the terms of the settlement agreement, because we have situations sometimes where one party is not able to pay, maybe sometimes a debt. So the party is not able to pay. What I do is call them back for mediation and enter new terms of settlement. Sometimes, the economic situation, You know, sometimes the party may not be able to pay maybe at once or something, and then you don't have to call them back to say, okay, let's have another method of payment of the. So that is what I do. Thank you.
Hello? Hello?
Okay, so we've run out of time. I'm so sorry, we've run out of time. I think we might need to have a part 2 of this masterclass, maybe during the next conference. What do we think?
Let's start the part 2 now. Thank you very much for indulging me.
Yeah.
When Isaiah told me about the masterclass, I was very excited. And I thought it was going to be in the middle of the program. I didn't realize that it was going to be the last session. And then I got jittery. But let me say this, Isaiah and Diane and your team, the way I assess as a conference is I look at the room, and if it is full at the end, as it was at the beginning, it is a successful conference. So I congratulate you. The only other organization that has been able to achieve this feat is the WIMBI's conference, which is ending today, and I ought to be there, but this took precedence. There's a question I want to answer because many people have raised this with me. I was a member of the technical team that put up the Mediation Act, and we had to do this within a week because we had submitted the bill to the National Assembly, put in conciliation. The Singapore Convention was passed, and then we withdrew it and had to change conciliation to mediation, and we had a deadline. And I want to thank Mrs. Kolade. She worked with me. I mean, it was a sleepless 1 week. But the question people kept asking is, Mrs. Roberts, in this law, we have arbitration rules. Why don't we have mediation rules? And just to forestall, because this question was again asked of me yesterday, I want you to recall all the examples we have heard today and ask yourself, how can we encapsulate them in rules? If you do, we're going to lose the flexibility we've been talking about. And I always give this example. A retired judge sent a company to me and said, Mrs. Roberts, these people need your help. They need your stature to resolve it. I took it on reluctantly, and it went on for about 6 months. But I realized that the company kept calling someone because they said the key decision maker would be at the end of a telephone call. And then he became the emir. And of course, he wasn't going to attend a mediation. But we had resolved all issues except for 2. And the lawyer whispered to me, because I'd had a meeting with the lawyers to seek their cooperation to work with me, and said, Mrs. Roberts, he's the only one who can take that decision. So I requested to see him. And perhaps this may also answer what one of the speakers talked about. And they said, I have to go and see him in the Emir's palace. And I agreed. It took us 2 days to get there. I mean, I don't want to talk about that journey in my life again. I hope I don't have to take that kind of journey, but it took 2 days to get to the Emir. But before then, I'd done my homework. Who is he? What is he? What does it like? What is the culture of his environment? What is the staple food there? And they told me about one fruit and that he takes it. I bought the fruit, packaged it in a beautiful basket, carried it with me all the way. And we got to the palace the morning. It took me 1 month to get that appointment for him to see me. And then for the first 3 hours of my stay with him, we didn't talk about why I came. We were talking about everything else except that. And then he was the one who said, now, Mrs. Roberts, what do you want? And then I said, sir, you know why I am here? And he said, what exactly do you want? In 10 minutes, he gave me his answer and we resolved it. I had my laptop, did the agreement, he signed it before we left. And what is that lesson? We cannot box mediation into any corner. You have to flow. If you want to help the parties, you have to do what it takes. If you're passionate, there's no point going into mediation if you're not passionate about mediation. So please, those who believe that we should have mediation rules, Just listen to your colleagues, listen to their experiences, and you'd understand why we don't have mediation rules in the AMA. Thank you very much.
Thank you very much, Mrs. Robert. Thank you.
I just want to, I just want to quickly add, in addition to mediation rules, we could also look at a code of ethics for mediators and mediations.
Please, just to say that, Madam Chair, Organizing Committee, can we, if the time is up, or can we ask for 5 minutes? I'm seeing the Diane saying no, but because other than that, we must come now back to Slido because we have questions that we need to answer. And we promise that we must leave. So, Madam Chair, do we have approval for 5 minutes? Yeah. So if we don't have that approval, sorry, sir, then we may just need to quickly answer the questions.
It's because I'm not a lawyer, I'm a quantity surveyor. And if that would be the only thing.
Because of that, moderator, can we take his own question? Okay, please, let's take only that question, the last one.
Thank you very much. I really appreciate you.
But please, very briefly, very briefly.
Yes, I will. I'm a consultant QS. My name is QS Olajide, and I come in all the way from Calabar, Cross River State. The essence of asking this question is, we know in normal court jurisdiction, cases could be status bar. But in ADR, do we have such a phenomenon that maybe a case of 4 or 5 years ago will not be revisited? Working for a client that working for a contractor that the client refused to pay his money for a completed job over 5 years ago. And up to now, we have all the evidences, even his own project team confirmed, the status of the project due for payment. But the client is a high-level judge that is based in Ogun State, but project in Akwa Ibom State, consultant in Calabar, Cross River State. So how do I address this kind of issue? Which ADR is best suited for this one? Thank you very much.
I understand that the organizer, the chair of the planning has asked that any additional questions, please post them. We will answer and then that will be sent to you on the platform. But the ones that have been given, we can answer that quickly. Yes. So just, we shouldn't, because I think it will be just two of them, 2 minutes, fine. For the gentleman who just spoke, as we finish, please meet us. That's a consultancy. You have to pay for it. We can't give that for free. So let's now, Franca, you want to talk about voluntary?
Thank you very much.
Yes, voluntariness from Franca. Sorry, sir, we just have to go on.
Yeah.
Voluntariness from Franca, and then I'll take the one concerning expert, and then we'll just close. Thank you.
So the issue of the parties coming to mediation on a voluntary basis is a very fundamental one and very controversial because more and more courts all over the world are requiring mediation as the first step. So the question is, if they're requiring it, is it voluntary? And what happens when a party is forced to come to mediation? So a number of things happen. In some cases, a party says, fine, I have no choice. I'll just show up. And I've seen instances where they come and they say, I'm here, record my presence, but I don't want to do the mediation. So in terms of the court's requirement, it has been fulfilled. The parties came, the mediation failed. There are some instances where parties come involuntarily and they go through with the mediation and they actually do succeed. And in some countries, the statistics are like 80% that they've succeeded, even though the parties weren't keen to mediate. And were forced to do so. And in other cases, even if the mediation failed, they came away with more knowledge about what the other parties wanted. And even in those cases, because they came away from the mediation knowing more about the case, they thought it was a positive thing, even though they were forced to do it. But again, the fundamental rule of mediation is that it should be voluntary.
And just to conclude on that by saying that in the Lagos particularly, by subscribing to file the matter in the court there, you submitted, Lagos has mandatory mediation. And once you file your matter in that court, unfortunately, you are bound. But just to come, and we can talk some more about that later. Just to come back to the issue of I think the experts. I think that is important to say that as mediator, you cannot. And so what you did was a big risk. However, it played out well. If I were in your shoes, I would have referred the parties to an expert who would give them that assessment. And then, of course, based on that assessment, because you want to maintain your neutrality, this is essential. The mediator cannot. Then, of course, does a mediator have a post-settlement role? And I think that's the fundamental last point I want to make. The mediator's post-settlement role is the most important that the mediator has that ordered this one. 3 months after the settlement agreement, the parties got to a dead end. And because we had agreed that if there was any challenge, they come back to the mediator. They came back, we had another meeting, and we were able to smoothen the distance. Every other question we will answer and send to you. Thank you very much.
Thank you.
I'm going to start some trainings on the guidelines of the CIAB. One of the guidelines of the CIAB is a guideline called the use of mediation during arbitration. Now there's a guideline on it, the use of mediation during arbitration. And it's one of the things we'll be doing a training on. And I mean, that guideline is very, very good, very wide. It talks about on what occasions can an arbitrator become a mediator in the same matter. There's a guide on it. And I mean, you can look at the guidelines, but we'll be doing a training on that guideline. And I'm sure many of you will find it very useful. Thank you.
Thank you very much, Madam Chair, and my mother. Thank you so much to our esteemed speakers. Could we give them a round of applause?
Thank you so much, distinguished ladies and gentlemen, and thank you, our panelists, for that insightful session. I decided to come up with my co-compare, my Kenyan host, Samantha, so that there will be gender balance on the stage. You know, we already have 2 females with a doctor, and I don't want to come alone too, so I decided to come with my co-compare. So she will be welcoming to the microphone who is going to present the gifts to the panelists.
Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. Yeah, much better, thank you. My name is Samantha Masingeli. I'm from Kenya, as you can tell from my forehead and my accent. And for those who are not here during the YMG conference, I was the host, and we are doing this just to ensure that there is a bit of gender balance now that you've been seeing a lot of Chooks and Olisa. Are we happy to be here? So we have come to the close, and at this point, I want to call our past chair, Mr. Babajide Oguntipe. I hope I have said it right. Thank you. To come and give out the gifts. A round of applause as he comes up, please.
So as it comes, I just want to announce that this session is proudly sponsored by Matrix Solicitors. Can you give them a round of applause? And it would interest you to know that Matrix Solicitors is one of our gold sponsors. As a matter of fact, the golf tournament, the 9-hole golf tournament, is also proudly sponsored by Matrix Solicitors. For more information about our sponsors, visit page 3 to page 9 of the brochure, and you'll see all of our sponsors. Thank you very much.
Thank you so much, Olisa. I would like to invite Ms. Franca. Please come forward.
My pleasure. Give it to you.
Oh my goodness. Wow. Lanet Silk.
And our moderator, Chioma Jack. I usually say that Chioma is the only CJ who is not a Chief Justice. Okay, yet. And Chioma is really amazing. She has been my secretary to the conference planning committee of the Budget and Finance Subcommittee. A very wonderful woman. Thank you. So a photo session, please, you may just stay while we welcome the chair of Nigeria, our past chairs, and our co-chairs for a brief photo session. Thank you.
So as they're taking the pictures, how many of us play golf by show of hand? And if you don't play, please don't raise your hand. How many of us play golf? Don't be shy. Don't be shy. So we are expecting our buses to have about 7 people.
First vice. Please, first vice, kindly join the photo session. Mr. Busari.
Oh, also aspiring to play golf. That's better. Thank you. So our buses will be departing at 1 p.m. for the IBB Golf Club. So I've been told, personally, I don't play golf, but there's something called tee. Yes, tee off. So you're supposed to be there 30 minutes to tee off, not a minute after. So that means you need to be seated by 1 p.m. And also the goodie bags for the golf are with Daniel Ihueze. Yeah. So please
collect. The guy with the turkey jollof. So you can get turkey from him too.
So please collect them from him.
Okay. So also taking note of the following announcements. The networking launch will commence immediately after we are done with this entire session. And networking events would also proceed. I want to announce that the Arts Gallery networking session is proudly sponsored by YC Mekiao and Co. Then also take note that the first 150 persons to attend the dinner tonight would get a free mask. And for those who have kept asking the dress code, it is still dress to impress. It will commence at exactly 7 p.m.
So finally, for the dinner, please carry your tags with you. That will